Okay, this is killing me. I've done this so many times and I make all kinds of mistakes. Let's try this again. Hey, welcome to week 10. It's an exam week. That's going to be your major assignment, same kind of a format as you had last time. For the exam, good luck with it. I hope you knock it out of the park. If you have questions on your paper drafts and you want to talk about it, please come on into office hours. And I'm pretty sure Tuesday is going to happen. If something comes up and it can't, I will let you know, and then we can, I'll reschedule something a little bit later in the week. I got a couple things on the horizon here that may cause some issues. So let's talk about the trial process, or the process from arrest through trial. First thing that's important here is the idea of gathering crime data. And where does it come from? Usually this is handled in different chapters, but in this case we talk about it this week. In the 60s, with the rise in crime, basically because of a kind of a laissez-faire social environment, the government, FBI, decided to start to collect crime data. And that became the Uniform Crime Reports. And what it was just a big sheet, and when an agency would have a murder, they'd check a box. They'd have another murder, they'd check a box. And they came up with, FBI came up with 8 crimes. And of those crimes, these 8 are Part 1 crimes, serious crimes. Part 2 crimes are less serious crimes. But started to realize that that data, although providing some guidance, wasn't that thorough. And it wasn't until the late 1980s that the National Incident-Based Reporting System came along. And that provides a ton of information on victims, suspects, vehicles, property loss, weapons used, all kinds of stuff. Later in other classes, you may have the opportunity to learn how to mine that information. You may have that information available to you that you're going to need in graduate school if you go there. So with that, I mean, the National Incident-Based Reporting System provides some pretty interesting information. Nationally now, we are in the middle of a very broad discussion about the AR-15, the firearm, and based on a loose variant of the M16, the Colt M16. Now, with all of the discussion that's going on, you would think there would be thousands of people killed every year by the AR-15 because it's so deadly and it's only got one purpose, and a lot of the stuff that you hear propaganda-wise. When you look at the crime data in 2017 of the 36,000 murders, I believe it's 297 were committed by rifles, not AR-15s, but by all rifles. And the AR-15 number is obviously going to be much less. And you compare that to the number of people that are killed with rocks, hammers, bats, other blunt force objects. There's substantially more that are killed with blunt force objects. But that information is available by mining the data through NIBRs. Really good information there. Let's talk about the process from arrest through up to trial. So a person goes out and they get arrested. Misdemeanor or felony. In a misdemeanor case, they will often be released in the field in a citation. Sometimes they'll be brought to the police station for either processing, or if they're inebriated, drunk driving arrest, held for a period of time until they sober up and can be released, so that they don't go out and walk in front of a bus or something, and there's another problem there. So that's one way. In fact, in California, most misdemeanors, the police are required to release on a citation or after or from a police station on a written promise to appear, and not be held pending trial. Very interesting thing going on in California now. Senate Bill 10 was signed a few years ago by Governor Brown. Governor Brown, signature on the bill would have activated a no bail system for California, meaning that a person gets arrested and based on the level of their crime, they would not have to pay bail to be released. They'd be released in citation. So let's say somebody walks into Best Buy and grabs a $1,000 television set and walks out with it. And you laugh, but that happens all the time. Costco, that happens all the time. Walmart, happens all the time. So it's a $1,000 TV set. It's a felony now in California, but they would be released on a citation and not held for bail. SB 10 came up with a whole bunch of people that were adamantly opposed. A lot of law enforcement people, a lot of concern about public safety, that releasing people that have already committed crimes would just come back in and commit more crimes. Another group that didn't like SB 10 were proponents of it. And what they didn't like was changes that were made to it late in the process. And the changes allowed judges to make determinations regarding risk, and they could keep people in jail pending the court process. Interesting idea that proponents didn't like that because they didn't want to have that subjective nature with the thought that judges could be swayed in the political process by law and order proponents. Another group, and you can see this one coming, that had a big problem with SB 10 were the people involved in the bail bonds business. Dog, Beth, poor thing, bless her heart. They'd get jobs because that industry would fold. So an initiative was quickly developed, signatures were obtained, and now that SB 10 has been put off for a ballot initiative in 2020. So currently, we're in the same system. You get arrested, you go to county jail. If you're going to be held, you may be released on bail. And that bail is basically a big book, bail schedule. You might have heard that talking about, well, if I steal, cookies from the cookie jar in my house, the bail schedule is I got to do the dishes or some kind of thing. And go to the bail schedule, find out what the bail is, and then a person can post bail. If they can't, for a misdemeanor or a felony, if they're staying in jail within 48 hours, including weekends and holidays, they must be seen by a judge, Gerstein hearing, and basically see it a lot on the East Coast, or by an ALJ needs to review the case, administrative law judge in California. So how this works is, on the East Coast, you see it in movies a lot. Somebody gets arrested and the cop takes him directly down to the courthouse and gives him to the judge and says, this is the guy, this is what he did, and then the judge decides whether or not he should stay in jail or be released or the case dropped or something of that nature. California works under City and County of Riverside versus McLaughlin. And what happens in California is an officer makes an arrest. They fill out a form that describes the incident and lists their probable cause. When a guy is booked into county jail, that goes to the administrative law judge, who then reads that to determine whether or not there's probable cause to hold the person. And it can be whether there's there's insufficient evidence, or it could be an administrative function problem. The easiest one to illustrate that would be the document itself must talk about or must include the person's name. So the name of the defendant, Greg Gibbs, on the top of the form, address, demographic information, and then it has a narrative that the officer writes. On this date and time, I saw the defendant do this, this, and this. Well, that's all good, except my name's not listed in that box. So that would be insufficient probable cause, because you can't prove that it's the same guy. I know, but it's the rule. And the agency would be called, officer called back in from home to fix the problem, or if they can't, the person's released. Or if you can't get a hold of the officer, the person's released. That's the McLaughlin hearing. 48 hours, including weekends and holidays. So you get arrested on Friday at 8 a.m., Saturday at 8 a.m. By Sunday at 8 a.m., there needs to be a determination of probable cause. The next step in both misdemeanor and felony cases is the arraignment. Arraignment occurs within 48 hours, excluding weekends and holidays. Get arrested on a Friday at 8 a.m. Saturday 8 a.m. doesn't count because it excludes weekends. Sunday 8 a.m., Monday 8 a.m., Tuesday 8 a.m. would be the 48 hours. So that's the arraignment. In the arraignment, you set bail if it hasn't been already made. You are advised, or the defendant's advised of their rights to counsel, and a new trial or a new date, the next court date, which is a pre-trial hearing, comes up. So what happens in the pre-trial hearing is, in a misdemeanor, that's where the plea bargaining stuff usually takes place. It may take place at arraignment in a slower court, but in a busy court, you're going to come back, and then there's going to be the discussion about a potential deal. If there's nothing reached then, a trial date is set, and the judge and the defense counsel and prosecutors have already talked about how long the case is going to take, and then a courtroom is scheduled and a new date for trial. On the felony side, you've gotten arrested, not you, because nobody in this class got. The arrest, the McLaughlin hearing, arraignment happens, those are set, then you go to a pretrial hearing to where maybe potential plea bargain is discussed, and then if it's going to proceed to trial, preliminary hearing. The judge in the preliminary hearing, it's evidentiary, meaning you've got to call witnesses. This is where Prop 115 comes into play. The Victim's Bill of Rights. We talked about victim impact statements. And the Victim's Bill of Rights include the idea that police can testify to hearsay. So you don't have to call civilian witnesses or the victim in for the prelim. Really good for prosecution, kind of bad for defense, because you get a good look at whether or not a person's what they got to say, and you can get them locked down into a story on the witness stand. So if they tell something different, which frequently happens because they forget or a bunch of other legitimate circumstances, you can use that to impeach their testimony. And then with the preliminary hearing, if the judge finds there's sufficient evidence to go to trial, then the person is bound over or held for trial, held to answer. Bound over, held to answer. They go to the Superior Court, another arraignment, another preliminary hearing, another pre-trial hearing, and then they go to trial. Now, the only way that this gets a little bit goofy is grand jury. Person is being investigated. They may or may not be in custody, but the prosecution can take their case to the grand jury. It's in secret, meaning there's no witnesses. There are witnesses. There's no defense counsel. There's no reporters. There's nothing. It's the grand jurors and the district attorney doing direct examination on the witnesses and the suspect. The suspect can use that right to remain silent, that Fifth Amendment right, but there's no right to counsel. Their counsel can be sitting in the hallway, but they can't be in the room with them, in the grand jury room. Grand jury is composed of, I think it's anywhere from 19 to 23 people, depending upon the size of the county, and they're picked from the general public. You can apply to be in the grand jury, and there's a small stipend to get paid. Grand jury will hear cases, sometimes a lot, sometimes not so many, and then they will probably have some sort of a research project that they undertake, whether it's investigating the jails or a particular police department or some other particular issue. Maybe a state agency or a local agency is involved in, I believe the technical police term is shenanigans, and there's a corruption issue. But that's what the grand jury will do. The grand jury listens to the testimony of the people that are brought before them by the DA, and if they believe that probable cause exists, then they can issue what's known as a true bill. True bill is the document that says that probable cause exists. If it doesn't exist, then they can issue what's known as a no bill, which means that there's no probable cause. If a true bill is issued, and that's a perfect example, is Ferguson, Missouri, where the officer, the DA took all of the information and went to the grand jury. And in a grand jury hearing, even illegally seized information can be used, whether it's statements, whether it's a bad search. It can be used there because there's no defense counsel to object. When it goes to trial, that's a different story. But in Ferguson, the DA took all the information he had. He went to the grand jury. He attempted to get the grand jury to file a true bill, and they refused. No bill. So contrary to what many people, and even people in my classes believe, that officer was never acquitted because he never went to trial. Once a true bill is issued, person goes to Superior Court for their arraignment. Why no preliminary hearing? Because the grand jury has already established probable cause. Last big point here. In the field, the officer determines probable cause and makes an arrest. And remember, I told you, it can be pretty thin just because of that arrest based on suspicion for felonies. Now we go to the ALJ. ALJ looks at the information, and they determine whether probable cause exists to keep the guy in custody. Then the case goes to a felony case, will go to a judge, and the judge will determine whether or not there's probable cause for trial at the preliminary hearing. Grand jury establishes probable cause for a true bill. Okay, that's this all put together. Hopefully it wasn't too bad, and I didn't run over too much. In any event, good luck on your exam. Knock 'em dead. I'll talk